So the year 2024 is about to end, and in the last year we have witnessed various landmark cases which has been decided by the Supreme Court and which we have discussed in the recap series wherein major judgment has been discussed. But in this video we will be talking about the cases which are expected to be decided by Supreme Court in the year 2025. These are the cases which can change the way we look at the religion, law and society. So that is why it is imperative to have a discussion on these cases and the issues. My name is Dalistoni and you are watching InFocus by Drishti IAS. In this video, we will be talking about the cases which Supreme Court might decide. So looking at 2025 law, key questions of religion, society and law. Okay, so here we will be discussing these important things which are social as well as religious issues which are there. Other than that also we will be looking at the legislative related issues as well. Okay, so let's start our discussion. Herein we will be discussing that why we are discussing this. Then we will be moving to the next part, that is major religious cases. We will be talking about the religious cases wherein we will be discussing about the places of worship etc. which are there in the news. Okay, herein we will also talk about the hijab related case as well. Coming to the next one, state, society and individual rights. Here we are talking about the civil rights. Okay, so here we will be discussing on the issues of, let's say, privacy, let's say the issues which are there in front of the court which are having something to do with the individual rights as well as the society. Okay, moving further, challenges to the laws. Recently you must have seen that new criminal reforms has been brought and there are these laws which has replaced the older existing 3 laws. Okay, so other than that also UCC etc. they are in the news, so we will be talking about that. Significant legislative reform, so we will be talking about certain cases wherein the laws has been put forward, or you can say the bills has been introduced in the parliament, and we'll be seeing that there might be a chance that these laws will or they might be you can say subjected to the judicial scrutiny. So we'll be talking about all these things. We will be having a comprehensive view, all those things which can be discussed by the Supreme Court in the next year. So we'll be talking about that, and in the end there will be a practice question for you. Okay, so which you have to attempt and answer to me in the comment box. Okay, now before moving further, I would like to tell you that we are offering ISGS Foundation batch for English medium at our Noida center starting from 9th January 2025 at 6 p.m. and for Hindi medium that is 16th of Jan 2025 11:30 a.m. Okay, other than that, here Prayagraj we are starting from the 2nd of Jan 2025, Hindi medium at 6 p.m. and English medium at 5:30 p.m. Okay, if you need more details you can call on this number, that is 87501 87501, or you can directly visit the centers and get enrolled over there. Okay, now let's move further, and as I told you that we have discussed the major important judgments in the recap series. So we are having this series recap 2024 wherein we are discussing all the important developments which has happened in the year 2024 and which are relevant for our UPSC examination. So we'll be discussing them in the field of be it government schemes, major summits, science and tech, environment or awards or major judgments etc. we'll be discussing in this particular series. So you can go to the Drishti IAS English channel and then you can click on the playlist that is recap 2024. Okay, now let's come back to our discussion that is related to the Supreme Court's way ahead in 2025. So let's see. The year 2024 saw a significant departure from the alleged judicial evasion. It is said that before 2024, most of the time it has said that Supreme Court has gone for the judicial evasion. Okay, now there are terms like judicial activism. That means that judiciary is taking a proactive role. Now when we are talking about the judicial evasion, that means that judiciary is having a lukewarm response. Okay, so here you will be saying that whenever there is a majority government, so you will be saying that judiciary might have a step back. Okay, because the mandate is with the government over there. So that is the case, but in year 2024 we have seen that that is not has been followed. Okay, there are certain cases wherein very progressive steps has been taken. So we'll be talking about we have talked about that in the you can say recap 2024 series, which you can watch. And then when we are talking about the year 2025, the Supreme Court under the Chief Justice of India will take several important issues. Now there will be 3 Chief Justice in the next year. So here you can say CJI Sanjeev Khanna, which has been already appointed till May 13th, and then CJI Bhushan Ramakrishna Gawai. Okay, so he will be there for the 194 days, and CJI Surya Kant from November 2025 to February 2027. Okay, so here under these CJIs you will be seeing that there will be various you can say important development which will happen. Now we are talking about these names because this is based on the seniority. Now if there is a change in the process, that might be a different thing, otherwise this will be the on the basis of the seniority. Okay, now these issues might impact the personal lives and religious beliefs of the citizen as well as their relation with the state law. Okay, so that is about the reason why we are talking about these issues right now. Okay, so now let's see the first one, which is related to major religious cases. Okay, now first is Places of Worship Act. Now we have discussed it various times that there is this act which was enacted in 1991, and this act says that when we are talking about the places of worship, the status of these places of worship, or you can say the nature of these places of worship, cannot be changed. Okay, let's say if there is a particular, you can say, place of worship which is belonging to a particular religion. Okay, let's say of a religion A. Now you cannot change it to a religion which is having another religious denomination. Okay, so that is what this particular act says. Now what will be considered as the nature of that particular place of worship, as it was on 15th of August 1947, as the nature of the place of worship which existed on the date, that is 15th of August 1947, that is the date of our independence, that particular status will remain, that particular nature will remain. Now because of which you will be seeing that there will be no new case which can be entered. Now there was one exception, that was the Ayodhya judgment. Okay, so because that was already under the litigation, that was kept out of it. Okay, but otherwise you cannot go for registering a new case. Now the thing is, when you are saying that you cannot change the status, you cannot go for the registration of the new case over here, so that means that you are putting a cap on the judiciary's power, or you can say you are putting a cap on the power of the courts to go for the judicial review. Now that was one of the contention. Second contention was this particular date. Now this is an act which was actually enacted retrospectively from this particular date, that is 15th of August 1947. It has been questioned that what is the significance of this particular date, because it is arbitrary. On this particular date we got independence, but it has nothing to do with the religion. Okay, so why is that the places of worship and their status is decided by this particular date? On these two factors this law has been challenged. Okay, recently there was this observation by the Supreme Court which has said that all the cases which are already under the scrutiny in the High Court and the Supreme Court, okay, because in in a judgment which was there, or by the our former CGI, that is D.Y. Chandrachud, he has made an observation. He has said that we cannot change the nature, we cannot alter the nature, but we can decide the nature, on the basis of which various you can say cases has been taken by the lower judiciary or the subordinate judiciary and the high courts. Okay, so there are certain cases which has been under the scrutiny, and various order of the archaeological surveys has been passed. You must have seen about the Gyanvapi, you must have heard about the Sambal, you must have heard about the Ajmer Dargah. Okay, so these were because of that observation which was made by the CGI in 2022. Okay, because of which what happened is that there are various orders which has been passed by the court, and court has recently in 2024 gave an observation that till we decide the constitutionality of the Places of Worship Act 1991, till then no further order can be passed by any court in that regard. Okay, so basically the constitutionality of this particular act has been challenged in front of the Supreme Court, and till Supreme Court decides that, you cannot go for passing any order in any high court or you can say subordinate judiciary. Now we are saying that in 2025 we might have a look at this particular issue. Supreme Court might look into it and might give a judgment. Okay, so that is about the Place of Worship Act. Now moving further to the next one, that is Essential Religious Practice Test in 2020. Now in 2018 there was a verdict, okay, with respect to the you can say practice of excluding women from the Sabarimala temple. Okay, now in 2018 it was said that if you are putting any kind of restriction on the woman from entering from the temple, okay, so that is unconstitutional. Okay, so basically they have allowed women in Sabarimala. Okay, they have allowed the woman in the Sabarimala temple. Okay, so but in 2020 Supreme Court has referred it to the larger bench, and Supreme Court will be looking into this particular you can say issue again. Okay, now the issue here is that what is essential religious practice? Now essential religious practice is basically the thing which is core to a religious practice, or you can say core to a religion. Now who will decide that? Supreme Court will be going through various you can say text and all various argument will be heard, and then Supreme Court will decide what constitute this essential religious practice. Okay, and because of which there are various cases like Sabrimala. There is another case when we are talking about the entry of you can say Muslim women in the mosque. Other than that, also when we are talking about the Parsi community, when you are going for the intercaste in the interreligious marriage, in that case also they do not allow them to Tower of Silence, which is there, that is also a place of worship for Parsi community. So considering that, you will be seeing that there are various such relevant cases are there. Once the this test for the essential religious practice has been decided by the Supreme Court, that will impact the other cases as well. Okay, so that is about it, which will be decided by the Supreme Court in the coming days. Okay, so that is when we are talking about the so-called essential religious practices, a contentious doctrine evolved by the court to protect only those religious practices which are essential to the religion. Now, court says that if a particular practice is passing this test, okay, then only it will be protected by the you can say state. Otherwise, state can interfere with that. Okay. Now coming to the next is that is Hijab Ban. Okay, so in Karnataka government has come up with an order wherein they have banned the headscarves in the educational institution. Now this case goes to the Supreme Court, and now when we are talking about the this particular practice, it was observed that this is not essential practice to the religion. Other than that also, but there is this right of choice. Okay, it is a personal liberty that you decide whether you have to wear hijab or not. Now Supreme Court will be looking into this particular issue again, a fresh 3-judge bench to address the personal liberty versus essential religious practice related issues. Okay, now why it is happening? Because Supreme Court has given a split verdict. Split verdict means that there are two kind of rationale which are given. One rationale was that it is under the right right to personal liberty. Now personal liberty is a fundamental right. Okay, so you can choose whether you want to wear it or not. Second thing is, it is not an essential practice. Okay, so whether if it is not an essential practice, can state interfere here or not? Okay, so on the basis of these two things, they have referred it to a larger bench, and larger bench will be deciding on the issue. Okay, so that is about the hijab. Now moving further to the next issues which are related to the state, society and individual rights. First is Citizenship Act amendment, which was done in 2019, under which there is this section 6B of the Citizenship Act 1955, which was changed, and the 6 communities, one is Hindu, Sikhs, Buddhists, Jain, Parsi and Christians. People from these communities, if they have entered into India before 31st December 2014, okay, and they are from the state countries like Pakistan, Afghanistan and Bangladesh. Okay, if they are from these 3 countries and these 6 community people who has entered before 31st December 2014, they will be given some kind of relaxation in the, you can say, citizenship. They will be given the citizenship, and they, in this particular amendment, they have excluded Muslims. The rationale was given that these 3 countries are the countries where these communities are in minority and are persecuted. Okay, and these are Muslim majority you can say countries, and that is why Muslims has not been included over here. Now this particular amendment has been challenged in the court, and court will be deciding on that. Okay, so challenge to the amendment, 2019 Amendment Act is pending, so Supreme Court will be deciding on that. Coming to the next one, marital rape. So in 2022, okay, 2022, Delhi High Court said that marital rape is not a crime. Basically, the thing is, there is no concept of marital rape in our criminal laws. Okay, it is generally said that whenever there is a non-consensual sex, okay, if that is there, and there are some provisions which are there in the old laws as well as in the new laws. Okay, if this is having a connection from those particular provisions, then it will be considered as the rape. Okay, otherwise when we are talking about a married man having sex, be it consensual or non-consensual sex with the wife, okay, and which is or the wife has attained the age of majority, which what I meant to say is that if there is a male and then there is a female who is more than 18 years of age, okay, they are in a marriage, okay, and they, if a male is having a consensual or non-consensual sex in the marriage, then it will not be considered as rape. Even non-consensual sex will not be considered as you can say rape. Okay, other wise there is one exception. If the female is less than 18 years, okay, female is minor, in that case, with marriage, without marriage, with consent, without consent, that is considered as rape. Okay, but as of now, when we are talking about the marital rape, that is concept is not there. In 2022, Delhi High Court said that there is no concept of marital rape. Now Supreme Court will be might be seeing this particular issue as well as in the future. So this is about the marital rape. Okay, now coming to the next one, which is review of the ED's power, okay, enforcement director's power to arrest, etc. So recently, you know that there was this bill which has been granted to Mr. Arvind Kejriwal. He is the former chief minister of the Delhi, and he was involved in some kind of money laundering related case, and wherein the, you can say, the court has granted the bail. Okay, now there is this twin test which is there with respect to the bail, which is given in the section 45 of the PMLA. Okay, so we'll be talking about the test. But now in this particular case, when we are talking about the you can say release order of Arvind Kejriwal, you will be seeing that there is a setback to the ED, because earlier there was this case, that is Vijay Madanlal Chaudhary versus Union of India, in which all the powers of the ED was actually upheld. Okay, and now the Supreme Court has granted the bail over here. So that means that there is some kind of dent which has been given to the powers of the ED. Okay, so here you can see the twin test condition for the bail is given under the PMLA 2002 under section 45 clause 1 of the PMLA. There are two conditions. Okay, twin condition, they are saying there are two conditions. One is prima facie evidence of innocence. Court believe that there is no you can say crime, or the person is not guilty prima facie because there is no evidence as such. Okay, so that is one condition. Second is non likelihood of the offense of going for any kind of offense again. Now this particular person might not pose a threat to the evidence, etc., and he may not go for any kind of offense in the future as well. Okay, so or he cannot tamper the evidence, etc. If these two conditions are there, so under PMLA also bail can be granted. Okay, so on the basis of this, the bail has been granted over here. Now the continuous judicial review of the ED's power are there in the news. Again and again court are giving some kind of observation, so we will be seeing in the future that they might discuss this issue again. Okay, now moving to the next part over here, challenges to the law. Now new criminal law, as I told you, there are three criminal laws which has been introduced to replace the old criminal laws. Okay, we have Bharatiya Nyaya Sanhita, okay, which has replaced the IPC which was there from 1860. Okay, then we have Bharatiya Nagarik Suraksha Sanhita, which has replaced the CRPC, okay, which is there from 1973. Then we have the Bharatiya Sakshya Adhiniyam, that is replacing the Indian Evidence Act, which was there from 1872. Okay, so these three acts has been introduced to replace these colonial laws. Okay, now there are chances that with the introduction of these from the, you can say, implementation of these from the July 2023, we can see that there might be some kind of challenges which can be posed to these laws or the provisions of the laws in the court. Court might decide on that. Other than that, some specific issues which has been raised till now is that the sedition renamed to Deshdroh. In BNS, it is generally said that we have not introduced sedition. Okay, but there is one section which is talking about Deshdroh or anything which is going against the country. Okay, so name sedition is not there in the new laws, but the substance is there. Okay, so that is one challenge which can be there. Second is controversy over the detention period and the FIR procedure. Earlier you can directly go for the filing the FIR. Now it is one provision which has been introduced that 14 days preliminary investigation can be done by a police officer. So there is a change in the FIR procedure. So that is one thing. Second thing is the detention periods, that is increased to 90 days. Okay, so that is also that can also be challenged in the court of law. Now laws of section 377, when we are talking about the homosexuality or the LGBTQIA plus related rights, etc. So this particular section has been altogether, you can say, removed from the new laws. So these things can be, you can say, questioned in the law. Now moving further, challenges to the Uniform Civil Code. Recently Amit Shah in Rajya Sabha debate has said that we will be introducing a Uniform Civil Code in all the BJP ruled states. Okay, now when we talk about UCC, you know that that is a DPSP. So state has to go for the implementation of the DPSP or the UCC under, when we are talking about the Uniform Civil Code, that is there in Article 44. Okay, correct me if I'm wrong, you can tell me in the comment box. Other than that, when we are talking about the Uniform Civil Code in Uttarakhand, they have implemented it from the 2025. They are saying that they will be implementing it. So there are certain provisions of Uttarakhand UCC which are there, like you have to go for the registration if you are living in a live-in relation. If you are not doing that, then there can be an imprisonment up to 6 months as well. Now the question is that when you are talking about the live-in relations and you are saying that you have to go for the compulsory registration of that with the state, that means that you are entering into the personal sphere of an individual. If a person wants to live have a live-in relationship, now why is that he has to inform the state? Because that is the personal liberty. Okay, so that is threatening the personal liberty or the right to privacy as well. Okay, so now that is there which can be challenged. Now you can say government has implemented this particular you can say provision with respect to the safety of the woman. But again, there is a doctrine of proportionality which has been discussed in the recap 2024, which you can go and see. Doctrine of proportionality is there, that the goal and the action which are taken for that should be proportional. Whether we have another way to go forward with that, or the you can say only option was this. So if we are looking at this particular situation, there can be another ways as well. Okay, so that is why this can also be challenged in the court of law. So this is about UCC which can be challenged in the court of law. Now coming to the next one, what about the future legislations? So when we are talking about the one nation one election, recently you must have seen that there is a bill which has been introduced by the current government in the parliament, okay, in the winter session. So this, if this becomes an act, there might be a possibility that few of the provision may be challenged in the court. Then SC/ST quota sub-classification. Supreme Court has made an observation that this SC/ST community or the group, that is not a homogeneous group. This can further be divided, and that is why there is a, you can say, chances that state might go for the sub-classification among the SC/ST quota, like on the basis of the, you can say, OBC, we are having this division, creamier and the non-creamier. Such division can be there in the, you can say, SC/ST quota as well. Now, as and when states are going for implementing these things, there are high chances that this can be challenged in the court as well. So in the year 2025, we can witness all these landmark cases in the court. So we have to keep a tab on that. Okay, so we have discussed all the important issues which are basically social issues which are there in the, you can say, current dynamics which we are living in. Okay, so when court decides on that, that can change the way we are looking at the things, be it state, be it law, be it religion, or be it society. Okay, that is why it is important to have a look at all these things. Now for you, there is this question for your practice, that is, the twin condition for bail under PMLA were upheld by the Supreme Court in which of the following case? Keshwanand Bharti versus State of Kerala, Menka Gandhi versus Union of India, Vijay Madanlal Chaudhary versus the Union of India, Kartar Singh versus State of Punjab. So you can attempt this question and answer to me in the comment box. With that, I would like to take your leave. If you have not subscribed the channel, please subscribe it. Have a nice day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.